right. So first on my screen is attorney Carolyn Gaston, and she is here on behalf of the defendant, Gregory Wolf. Ms. Gaston, good morning.
Good morning.
And Alex Ray joins us next. Good morning.
Good morning.
And Gregory Wolf joins us. Mr. Wolf, good morning.
Good morning.
I see you're in a car. You're not driving, are you?
No, my mom's driving. I was at the courthouse and my phone started dying, so I'm trying to hurry home.
Yeah, that's all right. I don't want anybody hurrying anywhere though. Good morning and good morning to your mother. I have read your motion, and I take it, Ms. Gaston, you received a copy of that as well?
I did receive a copy of the plaintiff's motion, Your Honor, and last Friday we filed a response.
I know.
Okay.
I'm jumping ahead of the game.
Yes, I did.
And I've also read your response and your counter motion. And I'm going to ask Alex if you received a copy of that as well.
Of the counter motion that I gave them 2 days ago?
No. That's your response. I got that too.
She did, Your Honor, because she served me her the response 2 hours by email, and we had emailed our motion to her, so she wouldn't have had my email had she not received, our
Sorry.
So we
Are you
got,
speaking
everybody's
about
got
the motion they wanted full custody?
Yeah, I'm talking about, your motion response, Alex?
Mm-hmm.
You responded to Miss Gaston's motion. I just wanted to make sure you got that. You did, obviously, because you responded to it. All right, so I've gotten everything and I've read everything. Let me tell you what I do know first. Is that the last custody and parenting time order was December 5 of 2017 on a judgment of support. Plaintiff was granted custody and parenting time was as agreed since November of 2019, at least according to the motion. The defendant father has been the primary custodian, and since 2020, plaintiff's parenting time has been sporadic. And in 2022, plaintiff reestablished parenting time as she had a unfortunate occurrence involving her live-together partner. Obviously, I'm aware of incidents of domestic violence, that type of thing. So I've read your motion, Alex. I've read your motion, Ms. Gaston. Why don't you go first, Alex? Anything you want to tell me that I don't know?
I do want to mention that I am the primary person that takes them to ear, nose, and throat, primary doctor, psychiatry, counseling through Redwood's going to start up. And I am the one that takes over schooling, IEPs, homework, and school counseling.
Okay, so you take a lot off Mr. Wolf's plate, apparently, right?
I also wanted to mention that Mr. Wolf has been claiming taxes for the last 5 years. Last year, he told me I could claim it. When it came down to tax season starting, he said, you cannot claim it. I said, okay, let me claim them next year. However, I do ask for reimbursement of some of the braces expenses. I paid $2,700 for braces.
Yeah, that's covered at the front of the court. They have a special office just for that. And you would probably, I think they have the forms online you'd have to deal with that, because that's really not subject to the motion today. But Ms. Gaston, response, your motion, whichever you prefer.
Okay, thank you, Your Honor. I just would like to short circuit it since I know that you have read everything. We have a interesting situation here where plaintiff has physical custody, but since 2020, has basically used the parenting time as agreed provision to allow Mr. Wolf to have primary physical custody of this child. There is no joint legal custody, so Mr. Wolf has been unable to access medical records, and those have not been shared by Ms. Ray to him in terms of any specific diet, which her original motion discusses. It appears that Ms. Ray has admitted Mr. Wolf's claims in her response to our motion, and she is now asking to essentially yank this child from his established custodial residence and have him placed with her from Sunday night through Friday. She's indicated that she takes the child to school, but quite frankly, my client is responsible for getting the child to school, and he is out of work at the appropriate times after school and delivers him before. He also lives with his parents, who are there to assist him in the event he's not available for parenting time. I'm quite concerned about the domestic violence allegations and about the overdose death situation that have occurred in front of the minor child on the rare occasions that the plaintiff has opted to have parenting time. So my request today would be for the court to enter an extended parenting time order to Mr. Wolf. I'm not certain what kind of parenting time the court would think would be appropriate for Ms. Ray. Send this matter to mediation at the Dispute Resolution Center, because I do know that finances are at issue, and potentially set it up for an evidentiary hearing in the future if needed. I know that's contra kind of the case law, because Vadvarka would say that you would be changing custody today if you did what I asked, which is why I'm not asking for a custody order today. But in effect, MCL 722.23 kind of bars you, bars changing the child's established custodial environment without an evidentiary hearing. So we're here in a quandary. I think both parties need to understand that when there is a court order in place, you need to follow the court order. Otherwise, we wind up in a situation like this where it's very hard to decipher what's happened. But I think through the court file and the parties' pleadings becoming admissions, our recitation of the facts is accurate. I do have a FOIA request out there on the other domestic violences, but I was able to locate an arrest record for the plaintiff for domestic violence from November of 2023. So there are concerns with her parenting time. And I, obviously don't know her. And so I have not had an opportunity to talk to her because I'm in the courtroom. I'm in the courthouse. I thought this was physical today as well. So I'm not surprised that my client is on his way in his car wondering where the heck I am. But anyway, so in short, that's what I'm asking for, Your Honor.
You would agree with me, would you not, that that your client would not have to show a proper cause or change of circumstances relative to Vodvarka as far as legal custody is concerned, based on the case of Sims versus Brugge, right? Because
I would, Your Honor, yes.
okay, so obviously that doesn't need to be, I guess, changed at all. I'm going to do a couple of things.
Your Honor, can I speak?
I thought you did already.
Oh, I'm sorry. I wanted to mention that the DV charge was expunged from my record. It was dropped. I do have evidence of the medical neglect, where he admits that the child was sick and vomiting, and he still did not provide care for him. And I do have documentation via pictures and texts that I did see my child within 2020 and 2020 through 2020 and 2022.
Okay, so here's what I'm going to do. What I'm going to do is, while we figure all this out, because Ms. Gaston makes a good point. When parties, I have absolutely no problem with parties making agreements on their own. That's usually what happens in these situations. But unfortunately, when the parties are subject to court orders, they have to do that in writing because otherwise it's very difficult to try and piece this puzzle together. It always ends up in a problem. What I'm going to do is, first of all, Ms. Gaston, if you would prepare an order maintaining status quo. Whatever the situation the parties have right now, I want it to continue. Both Mr. Wolf and Alex Ray. I want, no more hands up, please. This isn't school, okay? I want a status quo order, okay? So whatever's going on right now, I want to keep it. The second thing, I am going to adjourn both of these matters and order mediation at the Dispute Resolution Center with the cost to be split pursuant to a sliding scale. At that time, if the parties are not successful with their mediation, I'm not going to be completely shocked, but I hope it doesn't. Then the parties can bring it back here and I will rule on the proper cause or change of circumstance as far as physical custody, parenting time, and the like. Okay? That way it seems to keep everybody, everything above board. Any questions, Ms. Gaston, on what I need that order to say?
No, I do have a question, however, with regard to if we have to come back. Would it simply be a renotice of this motion unless there's other facts developed?
Yes, it would just
Okay.
simply, I would just pass on this motion, both of your motions. So I don't need a whole other dissertation. I would just pass on these motions, but I'm hoping that both of you, with the help of a mediator and Ms. Gaston's help, that we can bring this to a conclusion that everybody can at least live with. Okay.
Okay, thank you.
Thank you both very much. It was nice seeing both of you, or all of you, and we're adjourned. Thank you.
Thank
Thank
you.
you.
Thank you.